Dear students, I'm here to give you a brief overview of the subject private international law so that you have some clarity before going to choose for your optional subjects. So, what is private international law? Basically, when we talk about private international law, it is a set of rules or regulations or laws, anything you can say, which are applied by the courts wherein some foreign element is present. Now, what is this foreign element? The foreign element may be present in the form of maybe because two individuals are contesting some suit wherein the contract was formed in some foreign country, or maybe the person is citizen of a foreign country, or the person is domiciled in a foreign country, or the parties they solemnize their marriage in some foreign country, or one Indian national married some French national in Spain. So all these things comprise to be a foreign element. That foreign element may be present due to the contractual obligations. That foreign element may be present because of the matrimonial obligations, because the marriage was solemnized in some foreign land, or maybe some foreign national is one of the party involved therein, or maybe some tort was committed in a foreign land. So all these aspects give you all these aspects shows that a foreign element is present in the suit which the party is contesting. So the moment a foreign element is present in the suit contesting between the parties, that brings us to the domain of private international law. And in today's scenario, there are numerous situations where the principles of private international law may have to be applied. In all such examples which I just mentioned, because there is a foreign element present, that is why it brings these cases under the domain of private international law. So basically, when we talk about private international law, which are also called to be conflict of laws, now there is a reason behind this nomenclature, conflict of laws. Definitely, let's suppose and there's an Indian national who married a French national in US. Now, if these parties contest for divorce, how are we going to assess the situation? Because the purpose is to deliver justice. Now, you cannot just straight away apply Indian laws, you cannot straight away apply the French laws, or where the marriage was solemnized. We need to understand which court has the jurisdiction therein and which system of law is to be applied therein. So these are the two basic questions always in the cases of conflict of laws or private international laws, that which court has the jurisdiction and which rules are to be applied or are to be chosen by the parties to get the justice done. So this entire maze is called the private international law, because there is a conflict of law. On one hand, we have Indian laws. I'm talking about the example wherein we started with. One hand we have Indian laws, one hand we have French laws, and there may be a possibility of applicability of US laws where the marriage was solemnized. So and with all these things, we have tried to inculcate in the syllabus of private international law, as you will see, wherein the syllabus covers the subject extensively, wherein we discuss about international conventions in this particular field. We do talk about the laws in England, we do talk about the laws in some common law countries and the laws in India, how the laws are placed and how those laws are being implemented or executed. If you go through the syllabus of private international law, which you will see, I just give you a brief analysis or description of the syllabus. So the very first unit, when we start with, we talk about the definition of private international law, like what exactly is private international law, what do we understand by this foreign element, and what is the conflict of law being understood as. So this first unit basically talks about all these aspects, wherein we have some interesting and landmark judgments like Ruchi Maju versus Sanjeev Maju and MV Elizabeth case, therein trying to help us to understand the concept of private international law. From therein, we move on to the second topic, which talks about the domicile. The concept of domicile again is very important in private international law. It plays a very major role in order to decide the choice of law and the jurisdiction of the court therein. So herein we will talk about the concept of domicile. Then the next subtopic comes with the proper law of contract. Therein, we talk about, or we do discuss about the evolution of modern proper law theory with the help of landmark judgments, again, wherein we talk about Vita Food Products versus Eunice Shipping Company. We also talk about some other judgments, British India Steam Navigation and NTPC versus Singer Company. So in this particular subtopic, we try to analyze wherein the contractual obligation has been therein, and there is a presence of foreign element, and how do we solve the situation, how do we adjudicate upon this scenario wherein a foreign element is present. Similarly, in this domain of torts, there may be a situation where some tortious liability has been conducted in some foreign land, or maybe there's some foreign element is present in some other form. So again, in this aspect, we do talk about theory of lex fori, theory of lex loci, proper law, or social environmental theory, how all these theories work upon to solve the situation. And also at the same time, we try to draw a contrast between UK and Indian position through the help of the landmark judgments. And in the field of law of tort, how do we move further, how do we proceed to go ahead with choice of law in the field of private international law. So basically, whatever, maybe be it the contractual obligations, or be it the case of torts, or be it the case of matrimonial proceeding, if there is a foreign element present in whatever form it is, that brings the matter within the domain of private international law. And private international law, before proceeding further, the two basic questions are: what is the jurisdiction, means which court has the jurisdiction, and what is the choice of law. Once you solve this, then you need to proceed further. If you go down in the syllabus, when you go through that, you will see that the next unit talks about marriage matrimonial relief, again, wherein we talk about that when there is a foreign element present, how do we go about that situation, wherein in this particular subtopic we do talk about the capacity and formal validity of marriage, divorce, adoption and custody of children. And we have so many judgments here in Satya versus Teja Singh, wherein we talked about the recognition of foreign judgments, ex parte divorce decree has been obtained, and how that ex parte divorce decree can be executed in India. We talk about Lakshmi Sanyal case, Meera Devi case. So all these cases, along with the concept of what are the capacity or the formal validity of marriage under private international law. And lastly, we talk about the foreign judgments, the recognition and enforcement of foreign judgments. Herein we do refer to certain aspects or certain provisions, basically section 13 and 44A of CPC, how, if a decree or award has been passed in foreign land, whether it can be and how it can be executed within India. And lastly, in the field of arbitral awards, that how arbitral awards can be recognized and enforced in India, if they can be. So this is about the layout of the syllabus. If you will scroll through the private international law, so as I have told you, if there is a foreign element present between the suit which the parties are contesting, then definitely it is a matter within private international law, and then you need to have a clarity about that. Now, as far as the scope of the subject is concerned, because mostly the students are interested in that what is the scope of the subject in future. So definitely, given today's globalized scenario, where there is so much of transnational movement of individuals, this makes it a very relevant subject, because ultimately somewhere in today's litigations or in suits, there is some foreign element present, maybe in the contractual obligations or the tortious liability, that brings private international law into domain, and that makes the subject very much relevant and interesting. So if you opt for this subject, yes, definitely it will help you out in future, be it litigation or any other aspect.